It is the appeal will do.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
My Lord, the issue involved in this appeal is whether, my Lord, learned single bench directing the PHE to conduct a fresh survey on my land to identify whether my land is submerged because of the construction of dam or not. After, my Lord, Chief Secretary taken a conscious decision in 2018 pursuant to the direction given by the Learned Division Bench of this Honorable Court. So, Lord, should persuade my Lord, allow me to take some annexures before I come to the impugned order. My Lord, this is a second round of litigation. My Lord, may I just lodge your attention? We filed on page number 89. It's a first writ petition we filed in 2016. My Lord, we have annexed in page number 126. There was a draft notification, section 4 notification also, mentioning all the names of the writ petitioners, including the areas, my Lord. But they did not notify it. Thereafter, my Lord, there was a joint survey in 2011 and 12. And it was...
Where is this?
My Lord.
Where is this land?
My Lord, it is Liling Court, it is East Khasi only. East Khasi only. From here, around 20 kilometers from the main town.
Lighting Court.
Lighting Court. My Lord, thereafter, my Lord, the state has filed the affidavit in that petition. In para 7, they have admitted that the 3 times survey was done, conducted by the, my Lord, the Director of Land Survey, including the collector and the PHE, and come up, my Lord, with the areas under submersion. And thereafter, the collector has made the probable estimates of 6 crore or something, my Lord, to be paid to the land to the petitioners. Now they filed. That was the first the admission they made. Second ground they have taken in their affidavit. They said no, we are yet to invoke the land acquisition proceedings, and none of your land is taken by the government, and we are awaiting the sanction from the government. So in view of that, my Lord, Learning Single Bench disposed of my writ petition in 2017. May I just Lordship attention to that particular order passed by the single bench. My Lord, operative portion is available in page number 173. It says, my Lord, Land Council for the petitioner submits that due to heavy rainfall in Liling Court village, East Khasi Hills, the land of the petitioners have eroded, so necessary direction may be given to the respondent to provide compensation. It was a wrong finding.
Necessary directions be given to provide?
May be given to provide compensation to the petitioners. There was a finding. It's not a case of erosion. It's a case of submersion only. Now, he directed the petitioner to
submerging as a result of what?
My Lord, construction of the dam. After construction of the dam, my Lord, the water level rise up and it penetrates to the agricultural land of the petitioners. And the approximate the assessment was that nearly 30 acres of land.
Well, then what happened?
Thereafter, my Lord, he directed us to file a representation before the collector. So we say that collector is not the authority to take a decision. It is only the government. So we prefer writ appeal. Writ appeal, my Lord, on 26/9/2017, dispose of my writ petition, writ appeal, with modification, directed the Chief Secretary to consider my fresh representation and take a conscious decision preferably within 90 days. 90 days. That order was passed because, my Lord, the government made it very clear that the approval from the government is also pending. So that was a direction given in 2017. 90 days was given. We filed a fresh representation before him, and Chief Secretary has taken a conscious decision on 13 March 2017. decision and decided that, yes, we will give a compensation to the petitioners. And he has communicated to me on 14 March 2017 that, yes, the department has taken appropriate steps with regard to payment of compensation to your land, with regard to your land. However, subsequently, my lord, inter-departmental communication was on, and PHE requested the collector to, my lord, informing the collector that government has sanctioned 5 crores, and remaining, my lord, 1 crore, something will be paid, will be displaced before at the disposal of the collector after government grant the sanction. That was in 2018. However, PHE requested the collector to exempt the application of the new Act, 2013 Act, saying that the activities of construction was taken place till 2012, before arrival of the new Act, Land Acquisition Act. So kindly exempt. Perhaps collector has communicated to the PHE that I have no power to exempt. Therefore, PHE has asked the collector, then you go for fresh calculation under the new Act. And collector has done that exercise, and it has reached to 79 crores, including solution and others, and placed before the government that there is a new calculation under the new Act. Now, thereafter, the PHE has placed it before the government for appropriate decision. Government was kept pending. Therefore, in 2019, we are made to file a secondary petition before the learned single bench. And before the learned single bench, they do file an affidavit. Collector has filed an affidavit saying that no, that 6 crore earlier calculated was for damages. There was no record for damages. Throughout in the record is for the compensation. And
where does compensation arise? Unless it's notified, how does compensation arise?
My madam, I'll come to it. Madam, with due respect, madam. And thereafter, the PHE also filed an affidavit. They admitted the same thing as survey was done, everything. And the sanction was made. 6 crore has been sanctioned for payment of the compensation. Therefore, the matter came up, and the learned single bench directed the learned GA to produce a record of the chief secretary, how he has taken the decision on the representation. They avoided production of the records throughout. Thereafter, my lord, last year, in the month of July, learned single bench directed for fresh inquiry.
Fresh?
Inquiry. Directed learned additional district judge, Shillong, to conduct a fresh inquiry. So on 22nd July 2022, the learned additional district judge conducted the survey, and he has given a reply. And in his report, I'm sorry, stand corrected, report. In that report, my lord, he has stated, he found that land has been under submersion, and both sides of the river, of the upstreams, are under the occupation and possession of the PHE. That report was placed before the learned single bench. I prayed before the learned single bench, this is a finding. Land under submersion is my land. No other people come forward to claim it. And it is not the claim of the collector or the PHE that the land belongs to somebody else. But learned single bench, no, the report is very cryptic. It is neither here and there. Mr. Chairman will proceed for final hearing. I'm waiting for final hearing. Matter was proceeded for final hearing. And thereafter, before hearing concluded, my lord, the learned single bench directed the GA, why you did not produce the records of the chief secretary. Then thereafter, my lord, he has produced the minutes or the order adopted by the chief secretary on 13 March. And it is very clear that we have assured the petitioner that we will pay compensation. Therefore, the compensation amount will be placed by the finance department at the earliest. That decision was there, madam. However,
what is the final judgment by the single bench?
By the single bench, my lord, directed the PHE to conduct a fresh survey. That is first direction. Second, if after survey, if the land of the petition is found under submersion, compensation should be paid in accordance with law. My lord, there is no time frame. I have some grievance with it, with lordship permission. Second direction, my lord, after survey, if my land is not under submersion, then the department is directed to pay the 6 crore as a damages to the petitioners.
Why?
My lord, but the stand of the government is that the crops, the land has been damaged by the construction activities, and that amount calculated, it reached to 6 crore or something. So that amount should be paid to the petitioners. Now, my humble submission before the single bench is that there was no record to show that 6 crore is for damages. throughout in their own record, it says it is for compensation.
No,
Land compensation.
there are two things. There are two things.
My lord.
First and foremost is that notwithstanding right to property now being relegated, but still government cannot acquire private land
Yes.
otherwise than in accordance with procedure established by law.
Yes.
So if for the purpose of constructing a dam, land has been submerged, then it amounts to de facto acquisition. This de facto acquisition cannot happen without them following whatever the law is, whether it is of 1899 or
1894.
1894 or whether it is the 2011 or 2013, whatever that act is.
Right.
Now, of course, the later Act 2011 Act or
2013.
2013 Act,
Right.
right to fair compensation and such a big name.
Right.
That act also provides that if money has not been paid or tendered, then matter will be governed by the new act and not by the old act. So that also has to be ascertained. Now, there is a presumption in favor of the government that it will act in accordance with law, and therefore the applicability of any law for compensation would come only after a notification has been published. 4, 6, whatever,
Yes.
under the old act. I am not so familiar with the new act. Those have to be published, and then it can be done on an urgent basis also. Then there's a Section 18 procedure, ultimately Section 30 procedure, and that is how it happens. Now, Mr. Shangri sir, there is evidence in the Chief Secretary's report that the land is submerged. Is it perennially submerged or is it seasonally submerged?
With that regard, my lord, yes.
What does it say? Is it seasonally submerged or is it perennially submerged?
My lord, in the affidavit they have said is periodically submerged.
Is
Periodically submerged.
periodically submerged.
Submerged.
So periodically submerged will give you a right to damages, may not give you a right to compensation because that is not acquisition. But we have to see those circumstances. But the order of the single judge appears to be fair enough. All this will happen, and even the inquiry report filed by the district judge will also be taken into consideration, and then the government will keep this pending, ask them to take steps in accordance with law, and thereafter take up this matter.
My lord, yes. My prayer is twofold. Either set aside or, my lord, modify the judgment and direct my lord, the independent body, either, for example, collector, for example, or the session judge, or Central Water Board Commission, to conduct the survey. Because admittedly, my lord, my friend has disputed my claim, so I disputed his claim. So if the Central Water Commission...
No, that cannot be done, because after all, they are the government.
That is true.
They are the government. We cannot give it to some third party, which is, even under the act, it's the LA collector who does it.
But the collector is...
And the LA collector is a public servant.
Yes.
A servant of the state. So therefore that, yes.
But the direction be given to the collector, my lord, and conduct the survey within time frame and submit it before this honored court.
How can private land be taken over?
May it please your lordship. Lordship, in fact, your lordship, that submission took place only in the year 2011. Thereafter, your lordship, there is no such...
Even if it happens for one day, it's not your property.
And for that, your lordship, what happened? An amount of 6 crores has been sanctioned, has been made for a payment of damages, your lordship.
Thereafter, what is the status of the land now?
That is,
what is the present status of the land?
Government said that no land has been taken, your lordship.
Government may say no land has been taken. Government has been saying also there is no illegal mining of coal.
No, your lordship.
So therefore we understand what the government says.
Lordship.
But it is, what is the position on the ground? Get drone photographs and file an affidavit.
Lordship,
Get drone photographs and file an affidavit.
Another aspect of the matter I would point out, your lordship. There was an agreement on of 2007, where the writ appellant number 1 was the signatory to that, Your Lordship, where that land has been donated to the government free of cost without any claim of compensation. If Lordship is kindly please come to
Very well. Number
page
1 goes out.
228, Your Lordship.
Number 1 goes out. 80 others are there.
If Lordship is pleased to kindly come to page 228 of the writ of the memo of appeal.
Yes, one person goes out, others are there.
Lordship,
Others are not donated there.
There are 1, 2, 3, 4, 5, Your Lordship. 5% are there, Your Lordship. And that also has been done in
But there was allegation, my lord,
with the
appeal number 1
with the knowledge and
with the
approval
third party, no.
of the third party, Your
with
Lordship.
the third party, no. Government was never part of the agreement. I deny that one. Earlier round litigation also, government never bring on this record. Throughout the papers, my names are reflected there, my lord. Only, my lord, the calculation amount reached to a highest number, a highest amount. Therefore, government is by hook and crook bringing this document. They don't disclose whether the source of the agreement also.
Very well. What we say is that how long is the time given by the single bench?
No time frame is given.
Lordship, there is no
Therefore, I
time,
wait
Your
for
Lordship.
time frames.
Very well. The appeal is directed against a judgment and order of May 2, 2023, passed in the second round of writ proceedings, so to say, between the present appellants and the state. Paragraph. The matter in issue is whether the appellants, S apostrophe, parcels of land have been, in effect, taken possession of by the state following the construction of a dam
Yes.
and the alleged submergence of such land within the water body that has been artificially created upon the construction of the dam. Full stop. Paragraph. By the order impugned,
2.5.
certain directions have been issued, inter alia, for the Public Health Engineering Department of the state to conduct a fresh survey and identify whether the lands of the petitioners remain submerged after 2011 and till date, and if the lands are found to be submerged, initiate the process for acquisition of such land that remain submerged. Full stop. The further direction issued is that if the survey reveals otherwise, that only during some part of 2011, portions of the land had been submerged, which has not occurred since, then the previous money allocated towards damages to be paid to the petitioners, to the appellants, must be disbursed. Full stop. Paragraph. According to the appellants, the previous round of litigation culminated in a direction being issued by a division bench of this court requiring the Chief Secretary to the state to look into the matter and to take a reasoned decision thereon. Full stop. The appellants assert that The Chief Secretary's report in such regard was published on or about March 13, 2017, and it provided for compensation in excess of rupees 6.64 crore to the land losers, full stop. The appellants submit that by such time, the Land Acquisition Act 1894 stood substituted by the Right to Fair Compensation and what is the name of the act?
Rehabilitation Act 2013.
Right to Fair Compensation
Rehabilitation Resettlement Act 2013.
and
Rehabilitation Resettlement Act 2013.
and Rehabilitation and whatever settlement
Right.
Act 2013. Full stop. Paragraph. What the appellants insinuate is that in view of the Act of 2013, the mode of assessing compensation stood altered, and the methodology adopted by the Chief Secretary in his report of March 2017 would not pass muster under the larger compensation provided for under the Act of 2013. Full stop. The appellants claim that the PHE apparently requested the LA collector to waive the provisions of the 2013 Act so that the compensation as indicated in the Chief Secretary's report could be disbursed, whereupon the LA collector, quite appropriately, responded that he had no authority to waive the applicability of any provision of law. Full stop. Paragraph. What also remains the undisputed position is that no notification was issued under the Act of 1894 despite a draft notification in such regard having been prepared by the state. Full stop. The real controversy is as to whether parcels of land belonging to the appellants herein have been lost to the appellants forever, or they remain submerged for some period of time in 2011, or they continue to remain submerged periodically ever since the construction of the dam. Full stop. Indeed, if it is discovered that the lands remain submerged even periodically, it would tantamount to the appellants having lost their land and the state having, de facto, taken possession thereof, otherwise than by procedure established by law. Full stop. Paragraph. Accordingly, the state is directed to immediately ensure that photographs of the entire area, comma, including of the parcels of land claimed by the appellants, comma, are immediately taken by drones to establish the present position, full stop. Such drone photography must be conducted upon notice to the appellants herein, full stop. If reasonable notice of at least 2 days is given to the appellants, comma, it will be open to the appellants to depute one or more representatives to be present at the time that the photographs are taken, full stop. Paragraph, it is also necessary that the survey directed to be conducted by the order impugned should be done as expeditiously as possible, comma, and comma, preferably, comma, within 6 weeks from date, full stop. The completion of the survey in terms of the order impugned will be without prejudice to the rights and contentions of the appellants, full stop. Paragraph, the matter will appear a fortnight hence for the photographs to be received, comma, whereupon, comma, if immediate further directions are not required to be issued, comma, it will appear 7 weeks hence after the completion of the survey.
Obliged.
Much obliged.
From the main list, item number 1.
This is the airport matter, my lord, where the district judge was directed to complete the
Yes,
inquiry.
has he finished it?
My lord, today one application has come from one of the private parties.
Yes.
We're asking for 3 or 4 months, but whereas the direction was given to the district judge. Who filed this?
With the
Oh, sorry. I'm sorry, my lord, they have just served to me. It seems they have not filed. They have just served. I thought they have filed.
no, we are not going on that.
My lord.
This pertains to an inquiry directed to be conducted by the District and Sessions Judge Riboy pertaining to the acquisition of additional land for the purpose of the Umrah Airport. Paragraph, the district judge has written to the registry requesting for extension of time, full stop. Paragraph, the time to complete the inquiry and to furnish a report thereupon is extended by 3 months from date, full stop. Such direction is peremptory, full stop. The district judge will ensure that no unnecessary adjournment is granted to any of the parties, full stop. Paragraph, the parties are also requested to cooperate in the matter and not seek any adjournment at all.
Item number 2.
Mr. Chakraborty, you're a senior member, does not set a good example.
Sorry, my lord.
We can see your sleeves.
Sorry.
We can by law change the attire. This is not Indian. We can wear dhotis or lungis to court. But till we follow the tradition,
But I'm sorry, in fact, actually,
you must imbibe it.
I don't know for what reason. In Delhi nowadays, this is this is coming to vogue.
Delhi-
So I think we are making a mistake, man.
We are making a mistake, meaning?
No, we must be making a mistake by worrying only this.
By wearing all this? No. Delhi, the weather is different. Meghalaya, the weather is different. And Madras, the weather is worse, but they still maintain that discipline. Delhi, of course, what they don't do is they don't wear the gown between Holi and Diwali.
That is them.
That's in the Delhi High Court and thing. And I believe even in the lower courts, they can do without the jacket because of the heat. But here, you make a resolution and then let us adopt it. Then we'll allow pajamas and lungis from tomorrow.
No, Milord, it is not to that extent.
But till we do that,
It is not to extent. Milord, I am under influence from what is happening in Delhi. That's all. Milord. But otherwise, Milord,
let us not imbibe Delhi. We have an identity of our own.
oh, Milord.
Yes.
May it please, Your Lordship. Lordship,
Yes, what is this about?
Lordship,
This is about the jurisdiction of the district council to adopt the laws of other states. Our submission is that the district council has not been empowered under the 6th schedule to adopt the laws from other states. Unlike the Northeastern Areas Reorganization Act, when the
You are appealing for the state?
Lordship, I appeal for the district council, my lord. I had a prayer for an accommodation, my lord, because Lord Standing Council is on sanctioned leave. I'm praying for a
For the
week's time, my
state.
lord.
I'm for the state, my lords.
Very well. Now the respondents seek some time, let the matter appear
A week, my lord. I'm praying for a week.
10 days hence, but do it.
Lordship,
Yes.
much obliged, Lordship.
Item number 3.
Any answer?
My lord. I'll try to proceedings.
What is the corrected application?
That is, they're taking the plea of juvenility, my lord. And inquiry was conducted by us. We asked the Murshidabad birth certificate officer, my lord.
Oh, so nothing has come out. There is more than one accused over here.
My lord.
Oh, very good. Yes.
My lord, on the last occasion, your lordships granted me time to have instruction on this aspect, my lord. Because here, apparently, my lord, on a source information, the truck was intercepted at Barik Point, my lord, in Shillong. That was around midnight. And the truck was brought, escorted by the customs officers to the customs house, my lord, in Shillong. And at around 1:30 night, between 1:30 and 2, the truck was rummaged and the packets were taken out, my lord, from the truck. And thereafter, because of it was too late in the night, they stopped the search operation, my lord, and next morning they resumed the search operation. But the 18 packets of contraband, ganja, my lord, those were taken out from the truck at the night time itself. Now, it appears, my lord, the search was conducted in the presence of Superintendent of Customs, my lord. That has come on record, my lord. One Mr. Khain, he was the superintendent, he was present at the time of search. Of course, it is not clear whether he was there at the time of interception of the truck or not, my lord.
Give us the NDPS Act.
My lord, it appears, my lord, section 41, subsection 2, my lord.
So your superintendent, according to you,
Was present at the time of search, my lord.
did he comply with subsection 6 of section 50?
My lord, subsection 50 will not come into picture because this is search of vehicle, my lord, not of the body of the person, my lord.
So what you can do is 42.1.
42(1).
Enter into search any building conveyance in case of break open, search, seize such drug, detain and search, arrest any person, provided that in respect of holder of license, manufacturer, such power shall be exercised by an officer under rank SI, but that if such officer is reason to believe that a search warrant authorization cannot be obtained without affording opportunity for concealment of evidence or facility for the escape, he may enter and search such building at any time after recording the grounds of his belief.
My lord. So that was the precise ground taken by them, my lord.
So
But no reason was recorded, my lord.
Huh?
No reason was recorded.
Then
Our case, my lord, and I can place one or two decisions of the Honorable Supreme Court, my lord. Section 41 and 42 operate in different circumstances, my lord. When a gazetted officer is present, my lord, section 42 compliance is not necessary, my lord.
where is that? How do you get that?
Well, that is because Section 41, my lord, subsection 2 says any such officer of gazetted rank of the Department of Central Excise, Narcotics, Customs, so and so, can authorized any subordinate officer not.
No, just a second.
My lord.
Has that gazetted officer been empowered by any general or special order? First, you have to demonstrate that he has been empowered by any general or special order, which is a question of fact.
My lord. But what happened?
Was that fact?
My lord, customs officers are empowered, my lord.
Now, was that fact asserted in course of the trial? Which means you did not resort to 41. Not having done that at the trial,
My lord.
asserting a matter of fact at the trial, at this stage we can't allow you to do it.
That it seems there is nothing positive brought on record.
If there's nothing on
Indicate
record,
that
it
they're
means that
empowered.
you did not take recourse to 41.2. For 41.2 to operate, there is first the factual basis, thereafter the legal basis. If you did not establish the factual basis, the legal effect you cannot seek.
My lord, to this extent, it was established, my lord, that a source information was received. Source information was recorded in writing, my lord.
Please don't get us wrong.
My lord, I'll point that out, my lord.
We will try to assist you in every way.
My lord.
But the law has to be followed.
My lord.
You know, everyone is, no one is above the law.
Interplay 41, 42 and 43, my lord, even I am not very clear. But one thing we have
It
established,
depends on the day of the week.
my lord. My lord, exactly.
Depends on the day of the week. Otherwise, there is no confusion in the statute. But sometimes the confusion is in the mind of judges.
Because the statutes are worded in such a manner, my lord. Even one sentence is one paragraph, my lord. So, my lord, this much we have brought on record, my lord, that source information was received. It was reduced in writing, my lord. And then the superintendent of customs constituted a team and sent it for surveillance of the highway.
So, superintendent of customs was a party.
Only to the extent that he deputed a team of inspectors, my lord.
Very well.
Then, my lord,
Where is his authority? Where is his authority to allow such?
but 41 subsection 2 in my humble submission, my lord.
Provided he is empowered, so the moment you go to 41.2, you have to show that he is empowered.
But that is,
You have to show that argument, you have to show that evidence. It's not argument, you have to show that evidence.
evidence.
That he is empowered generally or specially.
Special order. Well, that has not been brought on record, it appears, my
That is
lord.
not
But this is a fact, my lord. All officers of Customs Department, my lord, above the rank of inspector are empowered by general order, my lord.
That does not also appear to have been an argument.
There's no argument also in this.
There is no argument in such regard. So which means you did not invoke that provision. Rule of law is most important. He may be a scoundrel, but a scoundrel also has an absolute right to be dealt with in accordance with law.
My lord, the fact of recording the statement, my lord, recording the source information,
Granted.
but my lord, this was not a case set up by them that he is not an empowered officer, my lord.
It's not a case that has to be set up. The fundamental facts you have to establish. And then section 29 comes into play. 29, is it?
Presumption.
Presumption?
35 and 54.
35.
35 and 54, Your Lordship.
Very well. Then they come into 29 is the other POCSO, sorry. They come in, but foundational facts you cannot miss. Foundational facts have to be proved. For instance, in POCSO, you have to prove that the girl is a minor or the victim is a minor. There is no presumption in respect of that. Over here also you have to show that it was done in accordance with law. And then they'll have to disprove, no, it was not found from our possession. Or no, it is not narcotic, it's not a narcotic substance.
No, but this fact, my lord, it appears, my lord, that this was taken for granted, my lord, that also printed in the empowered, my lord.
Unfortunately,
My lord.
the judge was alive to the issue. You have to do it in accordance with law. Show us any Supreme Court judgment which says that, when such is the obvious, then provision can be disregarded. Show us those. We'll quietly follow them.
I can try, my lord.
It says. Do you have any judgment which says it has
But
to be?
specifically to that extent, my lord, in my arm was a little difficult to get, my lord. There are very peculiar circumstances, my lord.
There are 1, 2, 3, 4 steps which have to be taken. Once those steps are taken, even over there, we'll give you some latitude, substantial compliance.
My lord. But to that, otherwise, to that extent, my lord, the requirements of 42, 43, we have complied with everything, my lord. There is a source information recorded in writing. The superintendent constitutes a team, my lord. The team goes and keeps the surveillance on the highway, my lord. Around midnight, the truck is intercepted. Truck is brought to the customs office. Independent witness search was conducted in front of independent witnesses.
In fact, we find it pretty harsh that, when it is a conveyance should be dealt with separately than a house or a person. Person should be different, conveyance should be different, and a permanent place should be different.
Yes.
But the Act deals with it all in the same breath. There is some kind of latitude for a person, but as far as conveyance is concerned and any other property is concerned, is the same.
The conveyance also, it appears, my lord, conveyance on the highway, my lord, a public transport conveyance is dealt slightly differently
That's
than...
accidental discovery.
My lord. My lord.
Accidental discovery is different.
My lord.
Discovery upon information, that is different. And that's has to be even more stringent. Because then you have a chance to plant.
But to that, my lord, 18 packets of ganja, my lord, 511 kg, my lord.
We don't know. We have to be blind to it.
My lord.
We have to be blind to it.
But if lordship permit, I can bring on record that particular document, my lord, which says that officers are important.
Not now. Not now. You can show us from the evidence it is there. Show us from even the argument that it is there. It's a notorious fact.
It appears that this was not even asked by them in cross-examination also.
Why should they? Why should they? You have a noose which is hanging. Why should I go and put my head into that noose? Let the noose hang. It's for you to get the noose to my head, not for me to go and put my head in.
So that is the only way now, my lord, for us to satisfy lordship that they are empowered officers. Otherwise, it appears that because taken so much of it as a granted, my lord, that no effort was made to prove this part, my lord.
One of the strangest matters that I did in a criminal appeal was the husband murdered the wife, beheaded the wife, and carried the head to the police station and admitted. After that, the investigating officer thought no inquiry was necessary. no murder weapon, no place of occurrence, nothing. He's come, he said, admission, over. He went scot-free. Because the only thing was hit by 25. Emotion, nothing can play a part when it's rule of law.
Look, this trial was conducted when Tufan Singh, the statement recorded under 67 was admissible as evidence, my lord. During the pendency, that was the reason this matter was kept on hold for many years, my lord. And after Tufan Singh has come 67
But this really wasn't an issue over here. Last time we saw this really may not have been an issue. But you get some Supreme Court thing, we are still willing to give you some time. He is out. He is not suffering anything. Whatever is your best, and then, because we don't remember the facts, you have to do the facts. We remember the legal issue, but we have to go into the facts and find out. And you go with the tooth comb with through the evidence to find that if there's any latitude, you can show it to us. Any possibility, you can show it to us, and then we'll try and see what degree of latitude we can give you. Because we don't think that small petty amounts to fix, people who cause nuisance, particularly in the festive season, police does it. But we don't think a superintendent of customs would plant 18 of those packets. It's difficult to believe, but then that's the law. Further time is afforded to the appellant full stop. Let the matter appear 2 weeks hence.
Deputy President.